Hey there, chapter 6, video 2. I had an incoming call as I was coming up with my last thought, but we actually ended at a good time, so we could just pick things right up. So, what I was saying is when we're dealing with tort law and we're trying to come up with standards, we run into a bit of a clash. And that is, do you have a hard and fast rule that becomes the determination as to whether one is in violation or not? Or do you use a standard? For example, reasonable care, reasonable caution would be a standard that would be open to interpretation. So, for example, you can be charged with a moving violation even if you're not speeding, if you're driving in a manner that maybe puts other drivers at risk, if you're not driving with sufficient caution. Okay. Um, Speed limit is a hard and fast rule. If you're going under the speed limit, you're not speeding. Above, of course, you are speeding. Drinking age is a hard and fast rule. But if you're of drinking age, then whether or not you're considered intoxicated may be not only sometimes perhaps open to interpretation, but the rules may differ, of course, by states. Now, the beginning of the chapter, and I usually don't read stuff from the book very often, but I want to share a little bit with you here. The beginning of the chapter on page 187 talks about all sorts of harms. A motorist collides on a highway, a patron in a bar punches the person standing next to him. I dealt with that case. I may have talked about it. I don't remember. I don't remember a lot of things this semester. And that was the one where the guy headed into the bathroom and the patron next to the guy went in and stuffed his head into the toilet and killed him. Okay, that's a tort. It's wrongful death, obviously, in that case. A newspaper inaccurately reports the arrest of a businessman for soliciting a prostitution. Okay, that would, that's sort of the claim with respect to Florida and the owner of the New England Patriots. But that would be one where it's a tort because it's a harm to someone's reputation, which may influence their business in the future. And then I want to get to the next one. A professor gives an unfair exam, because I have personal experience with this, so let me share it with you. My second year in grad school at the University of Oregon, we got a couple of new assistant professors that year. One of them had a tremendous amount of attitude. Okay, he thought he was really hot stuff. He did not stay at Oregon very long. Went off and made big bucks with consulting in the bond world, actually. But we had him for one of our second year econometrics classes. And prior to the final exam, we asked, is certain subject material going to be on the final? He said, no, we didn't study it. Lo and behold, we get the final. There's maybe 5, 6 questions on there. And one of the questions was on the material that he said he would not test us on. And there was only one student in the class of maybe 8 or 10 who knew the material and was willing to answer it. And the professor left the room. We went ahead, talked amongst ourselves, and agreed, so the majority ruled on this one, that we were not going to answer that question. And we didn't. And when we turned in our exams, he obviously knew that we had colluded. He was absolutely furious, and he wanted to go to the university administration and get us thrown out of school. And we went to the department chair and said, the guy lied to us. In other words, he caused a wrong, a tort, and tested us on something that he promised he would not, and therefore had harmed us. And so we resolved all of this by everyone in the class getting a B+. Did it really matter? No one has ever asked to see my transcript in all the years since I got my PhD, so it didn't matter at all. Okay, so back to the harms. How do we deal with these? It's not a violation of property. It's not a breach of contract. An injunction is irrelevant. Uh, you recall when we're talking about property law and all that, uh, we talked about paying damages with pollution, or an injunction that's temporarily stopped behavior without consent of the other party. The harm is not a repeated one. At least you don't expect to be hit. Even if you get into car accidents, you're not going to likely get into a car accident with the same party in the future. And we assume that the act was not intentional. If it was intentional, that's criminal behavior. So we're going to deal with criminal law in the last part of the semester. So these are unintentional acts. Bargaining is not feasible, as we saw in the context of property law or even bargaining to negotiate contracts. It's not feasible here. The transactions costs are way too high. What happens? Somebody slams on the brakes and you're going to say, don't hit me, I'm going to pay you money. Or they're going to offer you money for them to hit you. Obviously, it's impossible in a situation like that. And torts really impose costs on others, like external costs. It's more like pollution. It's more like a third-party action because we don't have a willing buyer and seller in the event that takes place. So the challenge in tort law is to get parties to internalize these costs, okay? If the injurer, the one who causes the injury, bears the cost of harm, they will have an incentive to efficiently reduce harm, because by practicing caution, you're reducing the chance you're going to be hit with the damages associated with the tort, okay? It's very simple. If you don't speed and you're not a reckless driver, you're less likely to get into car accidents. But if you get into a lot of car accidents, your insurance rates are going to go up. So there's a direct saving to you, besides the hassle and all of that of maybe being involved in a lawsuit, if in fact you take precaution. But it is costly to take precaution. That is the theme here. We know life is a series of trade-offs. The trade-offs in this case are going to be pretty obvious. Okay. So now I want to turn to two more things, and then we'll go on to video number 3. Back to the legal definition of a tort. You may recall with contracts we had promisor, the one who offered to do something, the promisee, the one who accepted the offer, and then consideration, the payment that sealed the deal, that sealed the contract. We have 3 elements of a tort as well. Number 1, the plaintiff is harmed. The one who is filing the lawsuit is harmed. That's number 1. Number 2, the defendant caused the harm. So you're suing the right person, you're suing the person who caused the injury. And the big number 3, the very big number 3, is there was a breach of duty by the defendant. There was a breach in terms of the actions that they were obligated under the law to undertake, and they didn't undertake them. Okay. So we will keep coming back to that, obviously, because in this chapter we're dealing with a lot of different definitions of harm, precaution, allocation, and all that. You'll see that pretty well as we go on through. The next thing that I want to talk about is simply the nature of the harm itself, and how do you even think about making someone whole in a circumstance where we have an accident that takes place. So the diagram here is a way of conceptualizing this. So we have 2 things that we value on the axes. We've got health on the horizontal axis. We have wealth on the vertical axis. I've drawn 2 indifference curves, U1 and U2, and we are initially at point A, okay? Then the person gets hit by a car, let's say. There's an impact on their health, as their health is reduced, and there's an impact on their wealth because maybe they're out of work, so they've been injured, they need treatment, maybe it's a chronic injury, we don't know yet, but maybe it's something that an operation or physical therapy or time will heal, and there's an impact on their earnings, and we end up going from A to B, okay? That is the identifiable harm that was caused by the tortious action, okay? So what is the nature or the goal of compensation here? The goal of compensation here would be a sufficient sum of money to get us from B back to point A. That will mean replacing the lost earnings and also providing for medical coverage, medical costs that will enable the individual to pay for the acupuncture, the physical therapy, the occupational therapy, the surgery, the recovery from surgery, the medications, whatever's necessary to get us from B to A. So the whole goal in torts is we end up from A to B and want to go back the other way. How do we think about compensation in a situation where you can't make someone better? I've been involved in lots of cases where someone ends up in a wheelchair. They're not getting out of the wheelchair. So in that case, can we make them whole? You bet we can make them whole. And that would be the movement from B to C. We can't improve their health, but we can give them added wealth, since both of these are normal and desirable goods. We can add to their wealth to compensate for the injuries that they suffered. So that's when someone goes for pain and suffering relating to an accident and they seek maybe millions of dollars to compensate them. Because if they get on to point C, remember, that is indistinguishable from A in terms of the person's utility. Okay, we will continue on in video 3.